Okay, the first one we have is on fighting medical bills, and our speakers will be Ben Fletcher and Sarah Pritchett. Ben is in the civil litigation and intellectual property area, and he is a senior associate, as is Sarah Pritchett, who works in the workers' compensation area, and she's in our St. Louis office, and she works primarily for our, I guess could be called our second in command, Mr. Banahan. And I will let them begin now. Thank you.
Thank you all for coming. Can you hear me okay? Is it on at all? Okay, can you hear me now? Okay. Just wanted to start off by welcoming you all again. Thank you for coming. I apologize up front. I have been battling with a cold this whole week, so I'm a little under the weather. I'm going to try not to cough in the microphone and blow your eardrums out. But when I was first approached to discuss this topic at the seminar, I wasn't really sure exactly what the topic was all about. I'd heard about the Manus case and how it is not a good case for the defense side. And once I started researching this topic and really got into it, it became apparent that this is really not a good decision for us. So I'm going to basically go over the Manus case and explain what it means to us and what we can do moving forward. To give you a little background, disputed medical treatment. Disputed medical bills are not anything new. We run into this with workers' comp all the time. A couple of the scenarios that usually result in unauthorized medical treatment are when you deny a claim from the get-go and the claimant goes out and treats on their own with their own provider, unauthorized. The other scenario would be you have an admitted injury and the employer-insurer provides treatment to the employee, but the claimant then chooses to receive unauthorized treatment on their own after they've been released at MMI by the authorized physician. Both of these scenarios are fairly common. However, they cause a problem when we get to settlement negotiations because we have all these unauthorized medical bills that are out there and that are a huge obstacle for settlement. So the result of these medical bills is the employer-insurer must decide, whether they want to settle the case or proceed to trial. There's a few things to consider. The amount of the medical bills is the first thing. We could be talking about a few $1,000s of unauthorized treatment that have been racked up, or we could be talking about tens of thousands of dollars with a surgery, hospital bills. That can add up pretty quickly. Another thing to consider is whether the medical providers would be willing to negotiate at all on the bottom line. A lot of times, as long as we emphasize that this is a disputed case and there's a possibility that you're not going to recover any of your billed amount, they're willing to negotiate with us. And this is something that our office does quite frequently, and we can handle that for you. We can negotiate directly with the medical provider who provided the unauthorized treatment. Sometimes they'll accept 50% for a disputed claim, but most typically it's between 75 to 80% of the original amount billed. It is important to emphasize, though, that the provider could end up with nothing if you go to trial and the injury is not compensable. So why are we talking about disputed medical bills? You might be wondering that. The Manus case is really the reason why we're talking about it. Manus versus City of DeSoto was a decision that came down in February of last year. Let me give you a little bit of background on Manus. The employee was a maintenance supervisor who injured his spine while moving decorative concrete stones. The employer initially provided treatment with Dr. Pruitt, but the employee was released after the employer's experts concluded that the claimant had only suffered a cervical strain as a result of the work injury. And this was determined after review of medical records and diagnostic studies that showed that the claimant had degenerative disc disease and symptoms prior to the date of injury. It's also worth noting that the employer also had an opinion from Dr. DeGrange supporting this position. Ultimately, the commission found that the claimant and the claimant's experts were more credible regarding the causation issue. And the big issue here is the medical bills. So when the treatment was initially cut off, the claimant went out and had back surgery resulting in medical bills in excess of $100,000. So once the causation issue was determined, then we're moving on to the medical aspect. At trial, the employer submitted evidence, including a hospital employee affidavit, which basically stated that the employee had no further liability after the charges were reduced and paid by the health insurance. The employer also presented evidence of testimony of the employer's finance director, which basically limited the employee's liability to co-payments and deductibles. I'm sorry? No, this was the regular policy. He used his health insurance through the employer to pay for the treatment. It was self-insured. Thank you. So the result in Manus was that the Industrial Commission ordered the employer to reimburse the employee directly in the full amount of the medical charges, and the Court of Appeals affirmed this decision. The rationale for this conclusion was that the affidavit of the hospital employee, who was the custodian of records for medical billing, was insufficient to overcome the personal responsibility contract that was signed by the employee. The affidavit that the custodian of records produced basically stated that she had personally reviewed the claimant's account and concluded that the billing records showed no outstanding obligation. However, that wasn't enough, and the personal responsibility contract was basically, the affidavit wasn't sufficient to overcome that personal responsibility contract. And if you're not familiar with what a personal responsibility contract is, it's basically that piece of paper when you go to the doctor and you're a new patient, you fill out all your information, and it's that sheet of paper that you have to sign off on, and it basically says that the patient is going to be liable ultimately if you're health insurance or you don't have another source of payment. So one thing to note is that these personal responsibility contracts, as far as I know, every medical provider uses them. The patient doesn't really have a choice on whether they sign them or not. If you want the treatment, you sign the responsibility contract. So the Court of Appeals cited two things that the affidavit did not include. It didn't include the custodian having any authority to fix, change, or extinguish the patient's liability. The second thing that it didn't include was it didn't show that the medical provider allowed the fee reductions for its own purposes, or that the reductions would have been made in the absence of a health insurance policy. The other rationale for the Court of Appeals conclusion was that the employer's finance director's testimony was inadequate. And the reasoning that they gave for this was that the testimony that the finance director gave was general, and it stated that no employee participating in the employer's group health plan had liability beyond co-pays and deductibles. And the Court of Appeals thought that this was just too general and not specific enough to the claimant's liability. So maybe if the director's testimony would have said that Manus did not have liability, then maybe this would have been a different outcome, but it's hard to tell.
All right, this is my part of the presentation is a discussion of the Supreme Court case of Farmer Cummings versus Personnel Pool. But the point, before we get into that discussion, there's an underlying principle that is shaping this discussion today, and that's application of what's known as a collateral source rule. And so what people need to realize is that the collateral source rule is from my perspective, a antiquated rule of law that developed or evolved over case law since the 1850s. And for those unfamiliar with it, the collateral source rule basically states in its simplest terms that a tortfeasor or defendant can't reduce their liability by pointing to an injured party and saying, hey, your injury is not that bad because you're going to be reimbursed by a collateral source. So applying that in present time, we would say, if you're injured, you, as a defendant, I can't limit my liability saying, well, look, you had health insurance, so you didn't pay for any of these medical damages. You're not liable for those, so why should I have to pay it for that? And that is an underlying element through these cases. It doesn't come out crisply, but one of the big factors in the Supreme Court decision in Farmers was the application of the collateral source rule. What the Supreme Court was doing was trying to balance the difference between applying the collateral source rule in a way so that the employee wasn't held liable for medical treatment. However, they didn't want the employee also to benefit from what's known as a windfall. Basically, they don't want a windfall in this category is considered to be a double recovery. You shouldn't get reimbursed twice for the same injury. And the courts struggle with balancing or harmonizing that effort. And the reason why the Farmer case was so crucial was that unfortunately, it was limited to workers' comp cases. But basically what it said is it cut everybody off at the knees from arguing over this notion of a write-off on your medical. Because we all know that when we go get medical treatment, nobody pays top dollar for the medical treatment if you're going through your health insurance company. And so in your civil cases, what happens is that the plaintiff wants to put up the total amount that they've been invoiced, that was invoiced on their medical treatment. And the defendants always want to say, no, we're going to put up the number of the write-off. And what the Farmer case said was, look, it's only going to be what the amount minus whatever was written off. You don't get to deal with monopoly money at that point since it doesn't really exist. And that was a great case. And it even got it better in tort reform that followed in 2005, which basically kind of put this application into statutory form. And the courts have struggled with the interpretation of this statute itself. And from a civil perspective, the way this statute has been applied in state courts is it has become a question for the jury to decide. And I'll explain what I mean by that. The plaintiff goes to the court, says, I'm hurt, and produces a stack of records showing its medical treatment and says it's $100,000 in medical treatment, so those are my damages, and please award me 3 or 4 or 5 times that amount, which is ludicrous. But that is the way the system plays out. We have the option as a defendant to do our due diligence and say, look, this may be the total stack, maybe $100,000, but we know from their invoicing that they wrote off 60% of it. So the actual damages are only $40,000. When the original thought process behind statute 490.715 was basically to say, look, it's going to be the write-off amount unless you can prove otherwise. And so the term they use is a rebuttable presumption. So the plaintiff can rebut the presumption that the write-off amount is the actual damages. So the way it plays out in court is the judge is in a position to evaluate the value of those damages and say, to bookend it from the full amount of the invoice to the amount that was written off. And then they submit it to the jury to decide on the value of the damages. And what it really ends up being is the jury gets to decide. They can go on the one end, give them the full amount, they can give them the low amount, or cut it off in the middle. And it becomes very difficult to set everybody's expectations as to what's going to happen as a result of that. But there's no level of sophistication in how the court goes about doing this. I mean, everybody's experiences with applying this statute is different. I mean, in the worst case scenario, judges are very candid saying, you put together a chart where you put up both numbers for the jury to be able to read, and they just sit down and take notes and figure out what number they want to come up with in between. We, as defense counsel, we'd like a more formal approach, but it doesn't always play out that way.
So what if let's just talk about your group health, self-insured, exclusively self-insured group health plan. And in the standard plan, they will have it written that if you make a recovery from another source, we have the right to come in and recover our payments. So in this case that you're discussing, was that ever discussed?
Well, do you mean that the employer fully funded the health insurance policy?
Self-insured by the employer. Then number 2, in their standard plan, they have it written that if you recover from another source payments that we have made on your behalf, we have the right to recovery directly from you.
So what you're saying is that the employer has the right to recover if the claimant receives an award for the amount. I don't know if that was ever addressed in Manus. I think that they still consider that a collateral source.
I would say, I would consider that a subrogation interest, and I think you need to pursue that aggressively.
But they're only going to recover what they paid out. So Manus still has 100,000 and they only paid out 40 or whatever it was.
Correct.
Still
Right, so
involved
they get
Manus.
their 40 back.
Sure, but they don't get their 100. Manus walks off with $60,000.
Right, no, I get that.
Which makes it difficult to set an adjuster's expectations at that point on the worst-case scenario.
Right, but then that plaintiff still had to pay back the health care. So he still doesn't have $60,000.
Yeah, he does. He only has to pay you back what you pay.
So the recovery would be $60,000. They have to pay back the 40.
Yeah, but the health care provider now has,
Healthcare provider is satisfied.
And that's what, I mean, what you're getting at is the reason why this is so unfair. They're manufacturing money as they go along. It's completely made up money. Nobody paid the doctors the full amount, despite the fact that the injured party is going to be awarded the full amount.
Yeah, it's already been written off. So the employee just ends up with a windfall.
Well, one of the things we talked about, and you let me know if this answers your question, but these plans aren't really straightforward in all respects. So sometimes, you've got the personal responsibility document that we all sign and say, yes, we got to pay mercy if my insurer doesn't cover this. But there's more to it than that. And the background of it is that a lot of times the insurance providers will negotiate with the medical providers that says, look, you're not going to go after our employees personally for any excess that we don't cover. But what we're talking about today, and we're open to discussion, is how do you get that into a case like this to establish evidence of that so that you force the commission or the division to deal with it? Because right now, I think the only conclusion anyone can draw is that the division's got a moving target and is not going to make anything easy or certain for an employer in the case.
the only thing I ever found that was pretty successful is if I could get a copy of the explanation of benefits that the employee was given through their, the insurance company, and therefore it showed what was paid, what was written off, what was the responsibility of the employee, and then it would give their co-pay, or, their deductible. So,
It doesn't sound like in this Manus case, they consider that as interfering with the personal, the whole thing is the personal responsibility.
Correct.
And correctly, he didn't pay the doctor, but he signed a document saying he would, and that was $100,000.
And basically, the court is saying that, there's always a possibility that the medical provider could come back and try to get that full amount from the patient. Now, whether that actually would happen is to be seen, but that's the theory behind it. So the result of Manus is basically we're left to decide between settlement and trial, and the decision's gotten a lot tougher. Settlements are going to be higher because claimants' attorneys are becoming aware of this case if they're not aware of it already. They're starting to realize that the employers have this increased liability, and they're using that to their advantage in settlement negotiations. Also, the increased liability at trial. We as defense attorneys have a duty to advise employers that there's a possibility that they'll risk, if they go to trial, that they'll be hit with the full amount billed, not just the amount paid by the health insurance provider or an amount that may have been negotiated during settlement negotiations. So what exactly is the employer-insurer's liability? Well, the collateral source payments, health insurance, deductibles, co-pays, and out-of-pocket expenses, anything that was paid by the employee, and also the adjustments and the write-offs. Moving forward, how do we satisfy our burden of proof? Well, an affidavit or deposition testimony from the provider detailing adjustments and write-offs and acknowledging that the reductions were made for the provider's own purposes could be a possibility, but we have to be sure that the provider, is someone with authority to change the patient's liability, that they would be the right person. So whether it's the medical bills custodian, whether it's the office manager, whether it's the provider themselves, we have to figure out who that person would be.
If I could chime in, I think everybody just needs to recognize that this may not be a simple, straightforward analysis either, because you might find third parties unwilling to cooperate in this process. Because if you take your investigation to full length, you might be asking to drive down and get to the original agreement entered into between the medical provider and the insurance company itself. And there could be a whole host of objections raised to prevent the disclosure of that document for obvious reasons. I mean, there's a number of business reasons why they would not want to get out there. And to be quite honest, nobody wants to get out there publicly and say, yeah, we have no intent of pursuing these individuals for the amount that they're going to be owed when they're still having them sign these personal accountability agreements when they come in for their treatment. So everybody needs to realize that you need to have a long-term outlook on investing into this effort to track down this type of information in order to use it in a claim.
The next thing that we need to show to satisfy our burden of proof is some sort of evidence showing the limitations of the employee's liability. What evidence will be sufficient? That's kind of the big question. How do we prove that the employee is no longer liable? And there's really not an answer, so we've just kind of come up with some ideas. The affidavit from the medical provider addressing the validity of the personal responsibility contract. Again, who is that provider? Who is the expert that you would be using? Is it the custodian of the medical bills, the office manager, or the physician themselves? Who has that authority? Also, is an affidavit sufficient, or do we need to take the provider's deposition? Do we need to have them testify live? And is that even a realistic option? Also, we need to argue that the personal responsibility contract is not applicable to insured patients. In Manus, the Court of Appeals reasoned that the commission could order the employer to pay the past medical expenses directly to the employee because the insurance company may be entitled to reimbursement from the employee. Well, after thinking about this for a while and speaking with general counsel for a local healthcare provider, we concluded that this is not necessarily true. And the reason being is that health insurance companies and medical providers have these contracts that Ben was referring to earlier that state that the medical provider cannot hold the patient liable for treatment covered by health insurance. So the question is, how do we get a copy of this contract? How do we get it into evidence? How do we get it from the provider or the health insurance company? And that's kind of the big question. So what if the risk of trial is too great? What if we don't want to spend all this time trying to figure out how we're going to get this evidence? Another approach that could be the best option, we don't really know, would be to go through the legislature and actually change the statute to help resolve this problem, or at least make things a little easier for us when we're faced with this issue. So when we're defending these cases, we're basically faced with more challenges and more unknowns now. Prior to Manus, the Farmer Cummings was kind of our guide, and in some cases, claimants' attorneys would even stipulate to only the amounts paid by the insurance company when a case would go to trial. This is likely to not happen anymore, and basically it's because the claimants' attorneys are figuring out that they can get a much larger award and they can get a fee on that. So they take a fee from those increased medical awards. And I apologize, this is not on your slide, but there was a recent commission decision on this point about 2 weeks ago that came out. The case is Bertels versus Houghton Mifflin. And just briefly, I'm going to give you a little information about it. The employer tried to distinguish Manus by arguing that the medical records and evidence did not include the personal responsibility contract signed by the employee. Thus, the employee had not established liability for the bills. Well, the commission didn't buy that argument, and they basically stated that the claimant only needs to do 3 things in order to satisfy their burden of proof. The first thing is they have to put into evidence the bills themselves. They also have to put in the medical records showing the treatment that gave rise to the medical bills. And then the third thing is they just have to have testimony from the employee establishing a relationship between the bills and the disputed treatment. So this doesn't really change Manus, but it does further the decision even farther in the employee's favor by not requiring the personal responsibility contract to even be brought into evidence.
Again, it's demonstrating that the division is treating this with a moving target. So it becomes more and more difficult to set your expectations on how to foster the right type of outlook on what to do in a case. It may be one of those scenarios where you pick one claim and run with it and pursue it all the way through. And what I mean by pursue it is dig down and prepare to go after the medical provider to try and get access to that document, which means trying to pursue a corporate representative deposition, which will be opposed, and there'll be a number of hurdles raised in that effort, mainly because it'll be something new and different. And going through a hospital provider and asking to take a deposition of somebody with authority to speak on behalf of this contract in an official capacity, there's going to be much resistance to it. Just out of the fact that it'll be new and strange to them, they'll be concerned as the long-term ramifications of it. The other side of this thing I would pass along is, this all rests upon this notion of the collateral source rule, which is antiquated. Even more so now in light of Obamacare, since we all now legally have to carry health insurance. And so the original basis or rationale for imposing the collateral source rule, and from a defendant's perspective, allowing plaintiff to enjoy a double recovery, seems to be expired. And there are a lot of opinions out there on the internet with articles addressing this notion, and it's just really unclear where they're going to go on that issue, which is why the legislative agenda might be one real reasonable way to go about pursuing a more definitive outcome, and in terms of how to set everybody's expectations on dealing with the claimant's injuries, because without it, it's a game of roulette to some extent. I think so. I mean, that anything would help, but it wouldn't be the same as a legislative improvement, though, because I think the only thing I think you really can take away from the Manus decision and the most recent one that we were discussing is that there is nothing that tells the court what they must do, and that's the problem. Because I would say, I don't with your work comp cases. I would say in this instance, these divisions were terminating their analysis prematurely. Almost like, oh, we got it, they're clear, let's go, let's move on. They got their money, let's move on, next case coming through. And defendants don't, or employers really don't have an ability to tell the court to slow down, this is what you need to do and you're not doing it. You got to protect yourself from the Court of Appeals.
Yes? Beth?
Ben, can you expand a little bit on, in the civil arena, when you're arguing outside of the jury about these, let's use medical bills, what are you showing the judge? What are you using as evidence? How does that work?
Well, it's pretty straightforward. At the end of the day, what both parties go to the judge with is an affidavit with medical records. And that affidavit is provided by the medical provider saying, I have the authority to state that the total value of these medical bills are $100,000 and that they were reasonable and necessary for this patient's treatment. So that's what a plaintiff attorney will go to with the courtroom, will be that affidavit. Oftentimes the judges don't even look through any of the medical records, and I'd be quite shocked if they ever did. And then defendants do the same thing. presumably with almost the same affidavit, but they just say, yeah, this is the affidavit and it's attesting to it, but here are also the write-offs reflected in here, indicating that although the total amount invoice was $100,000, the actual amount, when you take into account the amount right now, we're only talking about $40,000. And it becomes a rather disenchanting moment when you realize that the sum total of their analysis ultimately boils down to, look, you put up your number on a chart, you put your number on a chart, and go at it that way. There's not much that an attorney has available to him to resist the simplicity of that moment. And it's oftentimes treated as just, a matter of window dressing to get the case ready for trial. So that at the end of the day, the jury just gets presented with an exhibit with two different numbers, and they're left to make the final call on what it will be. Your big challenge as a defendant is to make sure you drive through and get those write-offs, which I can tell you personally, some hospitals handle it much better than others. Some hospitals treat that as if it's a secret that they're not willing to reveal in any fashion or form. And even to the extent where they produce records that are almost incomprehensible that we're looking to find out what the write-offs are. The pair hospitals kind of like that.
So what kind of trends do you see from coming out of the jury in that regard?
Well, I think a lot of times the plaintiffs are going to get the benefit of the doubt on those, and that's where the windfall comes in.
Ben, along those lines, talk about when you put the two numbers up. We, in civil as well as in comp, we have to dance around what's the insured paid as opposed to you're not allowed to state on those numbers. You don't get to put billed versus paid.
No, I think your restrictions, you can't get into discussing who the collateral source is. So that's why you have to tread very lightly. It seems very silly because everybody's advanced enough to the point where they all kind of get that it's coming from a medical system, but
You can argue that in front of the judge, right? I mean,
yes, in chambers. In a motion, you can do it prior to trial in what's known as a motion in limine and address that point so everybody knows what they're facing when they go before a jury. And that way you can advise a client as to where the number might go.
So when in comp, when you're dealing with a judge-tried case, are you seeing inconsistencies coming out of the commission when they're citing the collateral source rule? Because shouldn't a judge-tried case be able to
Well, I would say
consider that collateral source?
if it's a judge-tried case, the whole reason you have a collateral source rule is you don't want a jury to take that into account when they're assessing liability. That's in and of itself. The judge is treated differently because the judge is expected to have the intellectual wherewithal to appreciate both sides of the argument. So therefore, there's nothing to hide because the judge can, intellectually put each party's argument in its place. And so that's where the collateral source rule kind of comes in, is to kind of protect those less fortunate souls who don't have the wisdom that a judge has. Again, I think this is antiquated. And I think that the judge, this should be discussed, there should not be an effort to limit this information when it's in front of a judge or a commissioner of any kind, because they presumably have the ability to recognize both and just make their call. I would like to think that perhaps they don't want to address it because they don't want to, they don't like being the bad guy. But, at the end of a football game, nobody likes referees. So, does anybody have thoughts or questions about how we may alternatively go about accomplishing the establishment of this type of evidence?
Okay.
There's no more questions? What?
That's something that would,
It doesn't happen very often, but sometimes, you come across it. I mean, they would not have any expectation to ever have to pay those things back.
I think that would be a case that you'd want to take a risk on trying and see, what does the commission think about this? Because that's,
You take that risk and then let that be the standard for the Court of Appeals, that you don't have to be discharged in bankruptcy. That's the only way they
well, you don't want to start a trend, but that's definitely an interesting point and one that we should explore further if possible.
I think with that point, though, you don't know where I'd be careful with is that if the analysis still focuses on the collateral source rule, would they somehow try and construe the bankruptcy filing as a benefit, as a collateral source to the injured employee, which I think would be ridiculous. But that would be their argument, would be that perhaps the plaintiff's argument would be that is a collateral benefit that should not be taken into account on assessing the damages.
I was gonna say though, if the bankruptcy trustee got wind that this claimant couldn't recover those bills, they would immediately put a lien on them, wouldn't they?
Yeah, this would have to be a bankruptcy that's already complete. It couldn't be anything that's still pending.
It's an interesting point, though.
Anything else? Okay, you guys, you want me to use this thing when you're asking questions, or can everybody hear everybody? Do you want me to run around and stick the microphone in your face so everybody can hear and you can hear the answers? Is that better? Okay, I'm sorry about that. We'll do that